Hello and welcome to Chapter 7, An International Perspective on Courts. In this particular chapter we're going to be looking at initially the professional actors that are involved in the legal profession. Since we're concentrating here on the criminal justice system, we'll be looking at various advocates, the prosecutor and defense counsel, for example, and the judge. We're going to start with a review of the different kinds of legal training that these professional actors might receive, and then we'll look more specifically at the advocates, particularly the prosecutor and defense counsel. Legal training is something that is, of course, important in any system when you're trying to prepare your attorneys, your lawyers, to go into particular areas of work. The different career possibilities would include, for example, corporate attorney, law librarian, legal scholar, notary, individual public and private legal work that the citizen might go to get a will done, for example, or any other kind of assistance with real estate, etc. So lots of different options for people that have law degrees in pretty much every country. The ease, however, with which one can move amongst these various law careers depends to a great extent on the legal training, the type of legal training that was attained during the course of the education for the lawyer. The two primary ways in which this is carried out is either the unified legal profession or the separated legal profession. I'll note that in your textbook, separated legal profession is sometimes referred to as a specialized legal profession, but I'll prefer the word separated to distinguish them in this particular case. Under the unified legal profession, which is the one that we find in the United States, for example, all legal professionals are considered to have the basic knowledge and training that's needed to participate in pretty much any of the legal careers. Because of that, horizontal movement is fairly easy amongst those various careers. Now, certainly an individual would have to have some additional training if they went to specialize, but for the most part, a new U.S. law school graduate could, for example, start off with the public defender's office, attempting to pay off law school debts, and concentrate entirely on criminal law, but then later open a private practice in which that same person could now handle maybe some criminal cases, but might also start working with probate or workers' compensation, other areas of the legal profession. And that person would not have to go back and get different degrees that would just require becoming specialized in some of those areas that they aren't as familiar with. In this way, we're talking about the movement amongst the various legal careers as being fairly easy. This is, of course, one reason why in some jurisdictions in the United States that don't have a public defender system specifically, it's possible for an indigent criminal defendant to be assigned counsel that could be an attorney with actually no experience in the criminal law. In those situations, for example, an indigent defendant might be assigned an attorney who specializes in real estate law, possibly one who hasn't even done any court appearances. This is only possible because under the unified legal profession, we assume that regardless of what your specific career or area of expertise as a lawyer is now, you have received the training necessary to have a basic command of all legal careers, including the criminal career. The separated legal profession follows a situation in which each field has distinct entrance requirements, and because of this, moving amongst those various fields becomes much more difficult. New law school graduates might have an internship experience, for example, in fact probably will have an internship experience, in which they become specialists in whatever their chosen career path might be. In many European countries, the law students will declare a specific interest very early on and then prepare for that specific legal occupation, not only with the academic training, but as I said, with internships or apprenticeships as well. Because of this, it's kind of difficult to move among the various legal occupations, since one would basically have to go back and receive specific academic and practical training in that new area. And for that reason, the separated legal profession is much more difficult for an individual to start off in criminal law, for example, and they decide at some later point they want to go into real estate law. Not impossible, but very difficult, since the change in legal careers would also require different kind of academic and practical experience and training than what the person had received. Our particular interest in criminal justice means that we'll be focusing on, as I said earlier, the advocates and the lay judges. But we're also going to take a look at lay people. The lay people, by definition, of course, are not considered to be the professional actors, but we're going to be looking at them a little bit later on. We're going to consider how the variation occurs in prosecution, defense, judiciary, the way lay people are used, and even in the way that the courts themselves are organized. We begin with variation in prosecution. For the most part, this is accomplished either through private or public prosecutors. The first version, inevitably, was private prosecution, wherein the victim or the victim's family would initiate the action against the person that they believed was the offender. Private prosecution is not found very often in the contemporary world. There are some examples of it, which I'll mention in a few moments. In fact, we'll just start with that one. The private prosecution is the oldest of the two general approaches. It allows, as I said, the victim or the victim's family to initiate the action. Finland is an example of such a situation. In Finland, it is possible for the victim, because of some secondary prosecutorial rights that the Finnish law gives victims, it's possible for them to take action if the prosecutor decides not to prosecute the case. The victim then is entitled to bring charges and to have those charges considered by a court. Even though that is possible, it doesn't happen very often in Finland, but it is interesting to note that Finnish law still does provide for the victim or victim's family to take action when the prosecutor has chosen not to. The public prosecution version is the one that is much more widely found all around the world. It's accomplished by an office of public prosecution, or by a procurator, or by some other officials. The examples of these are going to be given in the next slide, and we're going to be using, as you can see there, public prosecution in the United States, procurator, France, and we'll look at Austria specifically for the other public prosecution officials. So taking first of all the Office of Public Prosecution. The United States is a good example of this because most people taking this course are probably familiar with the United States example. The person who serves as the public prosecutor might be called the district attorney. That title will vary a bit depending upon what state you happen to be living in. It's typically an elected position, and because of that, the district attorney is said to be more easily able to respond to the desires of the community, the desires of the electorate. And in this manner, if the current district attorney, for example, is using plea bargaining more than what the community members think that he or she should be using it, maybe somebody else will run for office against the incumbent and make promises to not use plea bargaining as much, or to use them in a different way. So in this manner, the district attorney is said to serve the public in a more direct way by being an elected official. The public prosecutor, the district attorney, for example, has very broad discretionary powers and decides what charges will be brought, and even if charges are going to be brought. This gives them a great deal more say in the way prosecution moves forward than maybe some of the other types of prosecution do. The procurator is a position in which the government provides an attorney who will be taking action for the private citizen. The attorney in this case then is acting in place of the citizen. This is a little bit different from what we're talking about under a public prosecutor, because the role there is for the prosecutor to represent the state or the government in action against the defendant. So the prosecutor is really taking more the role of the state. the role of the entire citizenship, if you will. So we have cases like the state of Texas or the people of so-and-so against a particular defendant. The procurator's position provides a little bit different kind of take on this. The procurator is really representing the citizen who has been harmed more so than representing the state. Because of this, the duties of the procurator is really to see that society's interests are served, but primarily in terms of what is working out best or what is the primary situation that we should be following here in protecting or acting in favor of or for the victim in the case. The duty is to see that society's interests are served rather than to secure a conviction. This is a key point because many people would argue that a key difference between the prosecutor and the procurator falls into this area as to whose interests are being served. And some even make the argument that because the prosecutor is serving the entire citizenship of the community, whether it be the district or the county or the state or the United States, that restricts them a little bit in terms of how to proceed against the offender, whereas the procurator is looking more at what is in the best interest or how can we best protect or act for the citizen. And because of that, the procurator, some people argue, doesn't have to pay quite as much attention to public opinion as the prosecutor might. This role of the procurator also fits fairly nicely with the inquisitorial process. You'll recall in our discussion of the inquisitorial process that it is a continuing, or the trial is a continuing investigation, meaning that as more information is compiled, as it becomes apparent that the accused or the defendant may in fact not have committed the crime, prosecution can be stopped. And the argument by some is that the procurator is more easily able to stop and halt prosecution upon deciding that the evidence is insufficient than can a prosecutor who might be more inclined to move forward based upon public pressure, public attention. Now that is in some ways an unfair distinction between prosecutor and procurator, but it is one that at least some people have wondered about and asked questions about, and it has led to some interesting discussions and some interesting journal articles as well. If that's an area of interest for you, you might consider that as one of your topics for your term paper, comparing the role of a procurator and a prosecutor in 2 or 3 different countries. Using the procurator in France as a particular example to elaborate upon this one, the prosecution in France relies upon 3 primary players, the judicial police, the procurator, and the examining magistrate. The judicial police are part of the police department, but they work specifically to investigate and have the power to detain and carry out other kinds of duties that the everyday police officer might not have. The procurator oftentimes is going to be working with the police very early on, and in addition will make decisions about charging, dismissing the case, etc. Along with the procurator and the judicial police in France and several other inquisitorial type countries as well, there's the role of the examining magistrate. And this person will direct and supervise both the judicial police and the procurator activities. The examining magistrate is somebody from the judiciary. It is not going to be, in all likelihood, the same person or the judge who is going to hear the case later on, but instead a member of the judiciary who is actively involved in this investigative stage and in making decisions, or assisting the procurator in making decisions regarding what kind of charges to bring forward and so on. This provides, on the very early stages then, a role for the judiciary that we don't find in other countries, especially those following the accusatorial or adversarial process. Just as an aside, those of you that might find this type of thing interesting, there is a fictional account entitled Bruno, Chief of Police. by Martin Walker. This is a good example of an English cozy. They're sometimes called murder mysteries, Agatha Christie being a primary example. But if you're interested in finding out more in a novel kind of setting, I would encourage you to take a look at the Martin Walker series about Bruno, working out of a rural area in France. This completes the PowerPoint for the first part of Chapter 7, and the next PowerPoint will be taking a look at variations in defense and in court organization. Thank you for your attention.